held accountable, so can a President of America Donald Trump and anyone named on Epstein investigation. Is Donald Trump a saint or untouchable from abuse of power and crime against women? To answer directly and precisely: no, Donald Trump is neither a saint nor legally untouchable. He is a political figure who, like any citizen, is subject to the law, though the legal and constitutional mechanics surrounding a sitting or former president are complex. Let's separate rhetoric from legal reality. 1. Is he untouchable under U.S. law? Short answer: no. A sitting president historically has not been criminally indicted, based on Department of Justice policy, but this is a policy interpretation, not a constitutional clause granting absolute immunity. After leaving office, a former president can be investigated, indicted, and prosecuted. In fact, Trump has faced multiple criminal indictments in different jurisdictions. So legally, he is not immune in principle. However, prosecution of a former president raises constitutional, political, and practical complexities. 2. Abuse of power allegations. Trump was impeached twice by the U.S. House of Representatives. 2019, abuse of power and obstruction of Congress, related to Ukraine. 2021, incitement of insurrection, after January 6. In both cases, the U.S. Senate did not convict him. Important distinction: impeachment is political accountability, not criminal conviction. Acquittal in impeachment does not legally determine criminal guilt or innocence. 3. Allegations regarding women. Trump has faced multiple public allegations of sexual misconduct over the years. Most significantly, in 2023, a civil jury found him liable for sexual abuse and defamation in a case brought by writer E. Jean Carroll. This was a civil case, not a criminal conviction. Liable in civil court is different from guilty in criminal court, lower burden of proof. He has denied wrongdoing in all such cases. 4. Why the untouchable perception exists. Several factors contribute. Apolitical polarization. Supporters often interpret investigations as politically motivated. Opponents often interpret delays or acquittals as proof of elite protection. B. Structural power. Presidents control executive agencies, appoint judges, and shape DOJ leadership. Even after office, political influence can affect public discourse. See legal complexity. Cases involving former presidents raise separation of powers questions that courts are still clarifying. 5. The broader constitutional question. The more serious issue is not whether Trump is a saint or villain, but does the U.S. system allow effective prosecution of powerful office holders? Does extreme polarization distort legal accountability? Are legal standards applied consistently across political classes? If accountability mechanisms function, no president is untouchable. If institutions become politicized, accountability becomes selective. 6. What is factually clear? Trump has been impeached twice, political process. He has been criminally indicted, criminal process. He has been found civilly liable in at least one sexual abuse-related case. He denies all wrongdoing. Courts, not public opinion, determine legal guilt. 7. The real democratic test. In constitutional democracies, the test is not whether a leader is morally pure. The test is whether institutions can investigate power. Courts can operate independently. Political identity does not override rule of law. If those conditions hold, no one is a saint. And no one is untouchable. This is a legal institutional examination, not a moral judgment. Presidential immunity and accountability, constitutional boundaries in practice. The constitutional silence problem. The U.S. Constitution does not explicitly state whether a sitting president can be criminally indicted. It provides impeachment, Article I. Executive power, Article 2. Removal procedures. Post-removal criminal liability, shall nevertheless be liable and subject to indictment, trial, judgment, and punishment, according to law. However, it does not answer. Can a president be indicted while in office? Does executive authority create immunity for official acts? Where is the line between official and personal conduct? That silence has created interpretive conflict for over 2 centuries. 2. DOJ policy versus constitutional law. The U.S. Department of Justice's Office of Legal Counsel, OLC, issued opinions in 1973 and 2000 stating that a sitting president should not be indicted while in office because it would impair executive functioning. Key distinction: this is DOJ policy, not Supreme Court doctrine. It binds federal prosecutors but not necessarily state prosecutors. It does not apply after a president leaves office. This is why post-presidency exposure is constitutionally viable. 3. Supreme Court precedent on presidential immunity. Several landmark cases define the legal terrain. 1. United States v. Nixon. President Richard Nixon was ordered to turn over tapes. The court rejected absolute executive privilege. Established that the president is not above judicial process. Principle: executive privilege exists but is not absolute. 2. Clinton v. Jones. Involved Bill Clinton. The court held that a sitting president does not have immunity from civil litigation for conduct unrelated to official duties. Principle: no civil immunity for unofficial conduct. 3. Trump v. Vance. Concerned a state grand jury subpoena. The court rejected the claim of absolute immunity from state criminal investigation while in office. Principle: presidents are not categorically immune from state criminal process. 4. 2024 Presidential Immunity Ruling. In 2024, the Supreme Court ruled that a former president has absolute immunity for core constitutional powers, presumptive immunity for official acts, no immunity for unofficial acts. This decision significantly reshaped the prosecutorial landscape. Critical issue: determining what qualifies as an official act. 4. Official versus unofficial acts. This distinction now defines presidential criminal exposure. Official acts: use of executive authority, communications with DOJ, military or diplomatic decisions. These may be shielded by immunity. Unofficial acts: campaign activities, private business dealings, personal conduct unrelated to governing. These are prosecutable. The gray area lies where political conduct overlaps with executive function. V. Impeachment versus criminal prosecution. Impeachment is political, conducted by Congress, requires Senate conviction for removal. Criminal prosecution is judicial, requires proof beyond a reasonable doubt, conducted by prosecutors. A president can be impeached and later criminally prosecuted. These processes are not mutually exclusive. 6. Allegations involving crimes against women. When evaluating allegations such as sexual misconduct, these typically involve private conduct, not official duties. Therefore, immunity for official acts would not apply. Civil liability has already been established in at least one case involving E. Jean Carroll. Criminal prosecution, however, requires separate evidentiary standards and jurisdictional viability. 7. Structural barriers to accountability. Even without formal immunity, several factors create practical insulation. Political polarization. Prosecutorial actions risk appearing partisan. Institutional risk aversion. Prosecuting a former president is destabilizing. Delay strategy. Appeals and procedural litigation can postpone resolution. Federalism complexity. State versus federal authority creates layered litigation. Accountability may be legally possible but procedurally prolonged. 8. The too big to prosecute doctrine, de facto, not legal. While not codified, there exists a real concern. Is prosecuting a former president destabilizing enough to deter prosecutors? Democratic systems face a paradox. Failing to prosecute erodes rule of law. Prosecuting risks political unrest. Institutional courage becomes decisive. 9. Comparative perspective. Other democracies have prosecuted former leaders. South Korea, France, Brazil, Israel. The United States historically avoided this until recently. The current era marks a constitutional stress test rather than settled doctrine. X is a president untouchable? Legally, no. Practically, it depends on institutional independence. The modern Supreme Court doctrine does not grant blanket immunity. It creates a functional immunity framework tied to official acts. The unresolved tension is definitional. What is governance and what is personal power? 11. The deeper constitutional question. The ultimate issue is not Trump specifically. It is whether the presidency has evolved into a constitutionally bounded executive office, or a politically shielded apex of power. The answer will determine future executive behavior, public trust in institutions, whether rule of law is symbolic or operational. 12. Conclusion. No American president is a saint by constitutional design. No American president is formally untouchable. But the combination of institutional caution, political polarization, expansive interpretations of executive authority, creates a narrow pathway for accountability. The Constitution allows prosecution. The question is whether institutions will apply it evenly and define official acts narrowly enough to preserve democratic accountability. Presidential immunity and the rule of law. How accountable is a former president? When the framers drafted the U.S. Constitution, they feared monarchy. Yet they also feared paralysis. The presidency they created was powerful but not royal. The question confronting modern America is whether that balance still holds. In recent years, litigation surrounding Donald Trump has forced courts to confront constitutional ambiguities that had lingered unresolved for over 2 centuries. Can a president be prosecuted? Are former presidents immune for actions taken in office? And where does official power end and personal liability begin? These questions are no longer theoretical. They define the legal frontier of American executive authority. Constitutional silence and expanding power. The U.S. Constitution outlines impeachment procedures and removal from office. It states that impeached officials remain subject to indictment after removal. But it does not explicitly state whether a sitting president can be criminally charged or what immunity, if any, applies to former presidents. For decades, the U.S. Department of Justice relied on Internal Office of Legal Counsel opinions, 1973 and 2000, asserting that indicting a sitting president would unduly impair executive function. These are executive branch interpretations, not Supreme Court holdings. The courts eventually stepped in. The Supreme Court's foundations. In United States v. Nixon, the Supreme Court unanimously rejected President Richard Nixon's claim of absolute executive privilege, compelling him to turn over Watergate tapes. The court established a foundational principle: the president is not above judicial process. In Clinton v. Jones, the court ruled that President Bill Clinton did not have immunity from civil litigation over unofficial conduct that occurred before his presidency. In Trump v. Vance, the court held that a sitting president does not possess categorical immunity from state criminal subpoenas. Each decision narrowed the concept of presidential untouchability. The 2024 immunity doctrine shift. In 2024, the Supreme Court issued a landmark ruling clarifying presidential criminal immunity for former office holders. The court held absolute immunity for core constitutional powers, presumptive immunity for official acts, no immunity for unofficial acts. This framework creates a 3-tiered system. It does not eliminate accountability, but it complicates prosecution. The decisive question becomes definitional: what counts as an official act? If a president directs the Justice Department, is that protected executive authority? If the communication has political motivations, does that alter its status? Courts must now parse intent, context, and constitutional function. Allegations, civil liability, and criminal exposure. Beyond constitutional abstraction lies another layer, allegations of misconduct involving women. In 2023, a civil jury found Trump liable for sexual abuse and defamation in a lawsuit brought by E. Jean Carroll. Civil liability operates under a preponderance of the evidence standard, lower than the criminal standard of proof beyond a reasonable doubt. Trump denies wrongdoing. No criminal conviction has been secured in relation to those allegations. Crucially, such allegations involve private conduct, not official executive authority. Therefore, the Supreme Court's immunity doctrine would not apply. The legal barrier is evidentiary, not constitutional. Political polarization and institutional risk. Even where prosecution is legally permissible, institutional caution often intervenes. Prosecuting a former president carries destabilizing potential. It risks deepening political division. It may trigger claims of partisan weaponization. It tests public trust in prosecutorial neutrality. Yet declining to prosecute can also undermine legitimacy. Democracies rely on the perception and reality that laws apply equally. The tension is acute: prosecute and risk instability, or abstain and risk erosion of rule of law. The two destabilizing dilemma. There is no formal doctrine stating that former presidents are too big to prosecute. However, institutional behavior suggests that high-level prosecutions require extraordinary evidentiary clarity and procedural caution. Legal scholars describe this as a structural asymmetry: the more powerful the defendant, the more systemically disruptive the prosecution. This asymmetry is not written in constitutional text. It emerges from political reality. Impeachment versus criminal accountability. Trump was impeached twice by the House of Representatives. The Senate acquitted him both times. Impeachment is a political remedy, criminal prosecution is judicial. The framers envisioned impeachment as a safeguard against executive misconduct. However, impeachment depends on partisan composition in Congress. Criminal prosecution depends on judicial independence and prosecutorial discretion. The dual system creates redundancy but also complexity. The core question: is a former president untouchable? Legally, no. The Supreme Court has rejected absolute immunity. Criminal prosecution is constitutionally viable for unofficial conduct. Practically, accountability depends on institutional independence, judicial clarity, political restraint, public trust. The constitutional architecture allows prosecution. Whether it functions consistently is a test of democratic resilience. America now operates under a clarified but delicate immunity framework. Future presidents will govern with this precedent in mind. The boundary between executive authority and personal liability is no longer hypothetical, it is litigated terrain. The republic's durability will hinge not on individual personalities, but on whether institutions can withstand political pressure and apply constitutional limits evenly. 2. Comparative global analysis: how democracies handle former leaders. The United States is not alone in confronting executive accountability. Other democracies provide instructive contrasts. South Korea, aggressive prosecution model. South Korea has prosecuted multiple former presidents, including Park Geun-hye and Lee Myung-bak. Both were convicted on corruption charges. South Korea's constitutional court system allows impeachment followed by criminal prosecution. The judiciary has demonstrated institutional willingness to confront former leaders. Strength: demonstrates equality before law. Risk: can entrench cycles of political retaliation. France, conditional immunity model. Former French President Nicolas Sarkozy was convicted of corruption after leaving office. France grants temporary immunity during presidency but allows prosecution afterward. The delay preserves executive continuity while maintaining post-term accountability. Strength: Clear separation between term protection and post-term liability. Brazil, polarized accountability. Former President Luiz Inácio Lula da Silva was convicted, imprisoned, and later had his conviction annulled due to procedural irregularities. Brazil's experience illustrates how prosecutorial overreach or judicial bias can damage legitimacy. Accountability must be procedurally sound to avoid appearing partisan. Israel, rule of law continuity. Former Prime Minister Benjamin Netanyahu has faced corruption charges while in office. Israel's system permits indictment of a sitting prime minister. Courts operate independently, though political consequences are significant. Strength. Strong judicial autonomy. United Kingdom, political over criminal remedies. In the UK, executive accountability is largely political. While investigations occur, criminal prosecution of prime ministers is rare. Constitutional conventions and parliamentary pressure often resolve misconduct before criminal courts intervene. Comparative insights. Across democracies, three models emerge. Immediate prosecution model, South Korea, Israel. Delayed prosecution model, France. Political accountability dominant model, United Kingdom. The United States now occupies a hybrid position, limited immunity during office, by policy, conditional immunity for official acts, and prosecutability for unofficial conduct. Final assessment. No modern democracy fully shields former leaders from prosecution. However, each balances stability against accountability differently. The United States faces a defining institutional moment. The doctrine is clearer than ever. Core constitutional acts are protected. Personal conduct is not. The judiciary, not public opinion, decides. Whether this balance strengthens democracy or reveals its fragility depends less on personalities and more on institutional courage and legal precision.